Barry is kind of the go-to person in the office of counsel. By the way, I forgot I had to turn on the stream, so I'm turning on the stream right now to an unlisted YouTube thing for those that want to observe this. But nevertheless, Barry is, I think, correct me if I'm wrong, you're the go-to in the office of counsel for these types of scams.
Well, I mean, I think it's more of a tag team thing with, Leonor basically screens these as they come in, and then they get assigned to us. And so it's a joint effort, in the office. But for consistency, they've usually been assigned to me and sub 3 in the grievance committee. But as to your question, I think I don't remember exactly how, and I don't think that in most of these, we never find out exactly how. We have a good educated guess how it happens. A lot of times these hackers are monitoring email communications between either the realtor and the buyer, or the lawyer's office and the buyer and the realtor. So we don't know exactly where they get into to get this information, but we know that they're monitoring the information, usually when it's a non-encrypted email.
That's scary stuff.
Yeah,
it really is. When I read this, my blood pressure went up quite a bit, and it reminded me why after the last RESPA change, I decided I'm done with real estate closings. I'm going to stick to my trial practice.
Well, I want to pose one thing, as much as I appreciate that, maybe we're just all on the same page with the opinion. I know one thing that I had heard in discussing this matter with another member of the committee, the full ethics committee, was kind of the question of, is this opinion getting into more of a best practices thing as opposed to lawyers' professional responsibility? And I guess I pose that. I don't, I guess I have my own personal opinions that I'll refrain from sharing right now, but I do think that could be a question that gets brought up at the ethics committee meeting, that, is this kind of stemming into just, more of a, maybe even a question of malpractice and so forth, as opposed to saying that a lawyer has a professional responsibility to be aware of and attempt to advise the client in avoiding these types of scams. So I don't know if anybody has any thoughts on that, but I thought it would be appropriate just to bring that up, because I would anticipate somebody might ask that at the full committee.
For me, I think you threaded that needle really well by emphasizing that it's about education and communication. And the communication can be in the form of an email, as long as attention is directed to that particular notice in the email, or it can be by letter, or it can be by other means. I think the opinion kind of indicates that, and says that we can't anticipate all the different ways or prescribe methods of practice, but we know about the different ways these fraudulent scams are occurring to the best we can, and we need to communicate with clients. So I think it does a good job of that.
Robin or Judge Hennon, do you have any thoughts on, is this something that it's appropriate for the bar to offer an opinion on?
I'm sorry, go ahead.
No, go ahead.
I will note that I had put best practices, direct instructions beside one of the opinions. So we had gotten close because I had put that there, but I agree with Alan that I think you threaded it really well in maintaining that it's educate yourself, communicate well. So I was satisfied with it.
And I was satisfied on the basis of client education. So I can live with it the way it is. And I think that the way that it's written clearly identifies it as to the intent of this committee to offer an opinion in response to it.
Brian, I would just add that, we've had about probably 7 or 8 of these kind of situations where funds were intercepted before they arrived at the attorney's trust account. And in our latest discussions on these with the grievance committee, I mean, there was some discussion about whether or not this is a best practice issue versus an ethical issue. But I mean, there have been now 2 instances where at least sub 3 and the grievance committee have said, hey, this deserves a letter of warning. It's a dismissal still, but a letter of warning in that it is a minor violation of the lawyer's duty here. And so that's been on their minds too. And so whether or not we've now crossed that line into an ethical issue versus a best practice issue.
Right. That's very
And I think to the extent that we can bring more education about this matter out there, I know the inquiry, this is about real estate transactions, but there was part of the, I think, initial inquiry was also about the fraudulent trust account transactions where they send checks, and I receive about one of those a month, fraudulent requests to get involved in a case, and I see those right away, and I send a typical email back saying I don't. I would have to have a face-to-face, I even say Zoom meeting now, meeting with you to determine my engagement and so forth as an attorney. And then I never receive another email back. But that happens a lot. It really does.
Yeah, and we've got another a separate subcommittee studying that particular inquiry. We split the inquiries because they are related, certainly in terms of a lawyer's handling of entrusted funds and so forth, and are just kind of being involved in some even purported entrusted funds. But we saw that as kind of 2 separate things or 2 separate fact scenarios. So there's another committee meeting on that particular opinion. I think they're actually meeting. If it's not this next Monday, it's the Monday after that. So we'll see if they have any opinion on or any opinion to present to the full committee in October. Well, I think that's very helpful. To your point, Alan, about a potential 5th inquiry, just kind of clarifying whether or not I guess if the client receives this warning from a third party, does that somehow impact the lawyer's responsibility to also provide the notice? I don't know if, I guess maybe we can talk about that. Do we think that would be an appropriate inquiry? Does that need to be clarified based upon the opinion? I think the opinion says now that it's the lawyer's responsibility. And I would think that if we're going to include that, I guess my proposal would be that, no, that doesn't really change anything. It's still the lawyer's responsibility to provide that information. So I don't know. Do you all think that would be helpful to kind of clarify that, having something from a third party doesn't necessarily just make everything okay, and lawyer can just, abdicate their professional responsibility?
It seemed to me that grievance was asking that question in their inquiry, and maybe Barry can speak to that. I don't know.
Yeah, if you want me to speak to that, that was part of it, and that was part of the factual scenario, was that the lawyer did not give the proper warning to the client. It came indirectly through, I think it was the realtor or someone else.
Yeah.
And so at least it was my opinion, and I think this was what was endorsed by the grievance committee, was that that did not absolve the attorney. That was his duty, not somebody else's duty to warn the client.
I guess my only question was, is grievance asking us to address that, what I call a causation issue, right?
Yeah.
Yeah. And I agree, Brian, that they shouldn't absolve the lawyer of his or her responsibility.
All right. Robin and Judge Hennon, do you agree with that? If I was going to draft an inquiry that would basically say, kind of set up the fact scenario that a third party, be it a realtor or the bank or whoever, provided these warnings about wire fraud, that does not absolve the lawyer of needing to provide this warning kind of independent of that third party's actions. Would that be in agreement with how you're looking at this?
Yes.
Yes.
All right. I will. I'll draft that. I'll add that inquiry after this call, and I can send it out to the subcommittee and just say, this was, after our conversation, we decided to add this particular inquiry to clarify that particular scenario. And I don't think we need to necessarily have a meeting again, unless everybody feels that I just botched it so much that that we need to talk, and we'll cross that bridge when we get to it. But I'll do that, and we can kind of take care of that outside of this phone call.
Brian, can I chime in here just with one additional point? I agree. It's so well written, and it hits just, I think, everything that needed to be in the opinions. But one of the things I was thinking of, and Leonore can probably chime in on this too, is that, we have the situation where most of the time this is the buyer's funds that are coming into the attorney's trust account. And it may be, though it's not clear in this scenario, that the attorney has been hired to represent the seller, and maybe not necessarily the buyer, but the attorney is, under our ethics opinions, is allowed to represent both parties. And in that situation, I mean, do we need to have some kind of clarification or a different opinion saying, well, even though the buyer is not necessarily the client in that situation, then these rules still apply. Do you see what I'm saying?
So you're saying that, I guess, if you are just want to make sure I'm understanding that correctly. You're talking about the attorney for the seller, and not the attorney for the buyer. This person is only representing the seller. That they may need to inform the buyer of this.
I'm raising that question. I mean, if the attorney gets to the point where he's representing both, essentially, he's going to be the closing attorney for both parties, then, I mean, does that change his duty to the buyer in that situation?
Brian, correct me if I'm wrong, but doesn't the rules state that in a real estate transaction, you're automatically providing a dual representation role?
Yeah, well,
if you're the closing attorney?
Yeah, we've said in prior ethics opinions that, essentially that, this is one of those things where you may have a, I guess, the concern was always that there was a conflict, but that in this particular scenario with the closing, that the interests are all aligned for the parties, and certainly the parties are consenting to the representation, so we don't have that particular concern. I guess I look at that as, if you are representing both, then I think this opinion still applies because you are representing the buyer. And so I think this opinion would kind of, to me, it's kind of, maybe I'll put it this way. I would say that this is applicable to both the buyer or the attorney who's representing solely the buyer, or the attorney who's representing both seller and buyer, because they're still representing the buyer in some capacity. And so I would think that this opinion addresses that particular scenario. I think the scenario where you have, somebody who's exclusively representing the seller, that maybe that's where some clarifying language might be needed, because sometimes we do have an attorney who's representing just the seller and who may be facilitating the receipt of those funds, just as the buyer is providing the funds and getting those wire instructions of where to send their deposit or what have you. But the person who's actually selling the house and ultimately receiving these funds, I don't know if they're getting wired stuff in, if they're wiring it directly into their personal bank account or what. I feel like maybe that's something, Barry, if you've seen, have you seen any sort of risk to the seller who's receiving funds on that?
Well, I will tell you that with the seller, it usually involves the trust account.
Right.
So you don't have the same issue that's being addressed here with this particular opinion. So for a while, all of our claims came from sellers whose proceeds were wired to the wrong place because the lawyer received an email saying, send it here, instead of what the original instructions said. But over time, about the time that Barry has the file that he had, I would receive phone calls from buyers saying, why didn't my lawyer protect me? I received an email telling me to send my proceeds here. And I followed that email and the money went to the criminals instead of to the lawyers, which
Mm.
is why the trust account is not involved, which is what makes this opinion important and relevant, and which helps the public see that as lawyers, we're trying to do our part to make sure they're protected and knowledgeable in the representation.
All right. So Leonore, do you think that I guess the first circumstance in talking about the seller who might complain because lawyer was the one that was duped? I guess I'm kind of understanding that to be a seller spoofed email where the lawyer gets some instruction that are fraudulent instructions of where to send the money. And of course, you have entrusted funds now that lawyer has received and is sending to an inappropriate place and not properly handling that. Is that a separate issue that is not yet addressed by any of our opinions in your, I guess, from what you're looking at? Or do you think we need to issue either a different inquiry or a different opinion to address that situation?
I feel like the grievance committee is handling those pretty clearly, and Barry, definitely weigh in if I'm not stating this correctly. But that's a clearer violation of Rule 115 because funds are being directed to a wrong location. And so then it raises the question, did the lawyer fail in his or her duty to safeguard entrusted funds? And it's my understanding the grievance committee is not having difficulty determining on the given fact scenarios of each case whether or not they think there's been a failure to safeguard. And a lot of it centers around whether or not the lawyer is communicating specifically about how they will receive information about where to send money and telling clients that they have a verification process in place. If I receive an email, I'll call you at a known number. So I think that's pretty well understood. And it's a clearer disciplinary issue that I think the grievance committee has been addressing with the files it receives.
And Brian, I would add to that is that, yes, in 2015, the Ethics Committee issued that 2015 FEO 6, and that is the one that deals with that scenario of the funds, of the lawyer being duped and sending the funds to the wrong account.
Right. Okay. Yes, I just want to make sure that was still sufficient. Okay. If I can ask Barry and Leonore, is there anything from what the grievance committee is looking for clarification? Is this opinion kind of clarifying the question or addressing the question that they have? I mean, I don't know if they're going to be, happy or I guess satisfied or dissatisfied with the answer, but as far as what you understand the grievance committee was looking for clarification, is there anything else that we should be addressing in this opinion?
I would say I'm not aware of anything, Brian. I think this does address the concerns that I've heard raised, by the grievance committee for this type of scenario. And I will just add, I mean, up until say the last 2 or 3 of these instances of the buyer's funds being intercepted, they had just flat out dismissed all of these similar circumstances, cases that were coming before them. But, these last couple have been so egregious about there was no warning whatsoever involved by the attorney that's what prompted them to ask for this guidance from the ethics committee.
My sense is pretty much the same as Barry's. As these kept coming in, it really became a question of, are we doing all that we should be doing to protect the buyers in these scenarios?
Okay. Well, Mr. Chair, what else would you like us to address at this point?
I don't have anything else to address. Do any of the other committee members have any other points to address at this time? Okay. So I guess, Brian, thank you for your good work on this, and certainly thankful for Barry and Leonore's help on this and understanding the perspective from which this comes from the grievance. That is invaluable. I move that we adjourn at this time, and I look forward, Brian, to receiving your email, which I'm sure will be equally well written for the other inquiry section, which I think needs to go before the last one. I would just suggest the last one has to do with whether you have to call about your any trust account violation, and we said no on that. Okay.
Yeah, I'll make that that last one. What's currently inquiry number 4 will become number 5, and we'll have a new number 4 that addresses the third party information or provision of information.
Okay. So thank you so much for your hard work and great work as always. I move that we adjourn at this time, and see everybody on Zoom next month, right?
That sounds great.
All right. Thank you.
All right. Thank